What happens at a DODD removal hearing?
In New Jersey, DODD is the statute that authorizes the state to remove a child without a court order. So typically when you hear DODD, I want you to think about emergency removal. DODD is actually the name of the senator who proposed the legislation that ultimately became law that now authorizes the state to make those types of emergency removals. If a child is removed pursuant to a DODD, you're going to have a court hearing within 72 hours, and that hearing is to determine whether or not the child is going to remain in placement. It is very common that if a child is removed on a DODD, that the child will remain in placement because the allegations were so severe and so significant that the court is usually going to err on the side of caution and say that the agency would not have removed the child unless it had substantial evidence that would have supported that the child is actually being harmed at present or is of such risk of harm that returning the child to the home is going to place the child in imminent danger. So normally, if a DODD happens, you do still go to court. You go to court very quickly. You do have a right to contest. And with the right DCPP attorney, you can actually have your child returned to you at the return date. But that doesn't usually mean that the state is going to close its case or that the state is not going to be authorized to proceed. They're still going to try to seek to find or ask the court to make a finding of child abuse and neglect at a fact-finding hearing. But the DODD is the first step in that process.